My dear brothers and sisters, as you may be aware, this is part 2 of the trial of Sheriga Alhaji Seydou Abagre, a customary chief enskinned by the Nayiri. So this is part 2. Our focus is narrow and legal. We are focusing on what happened yesterday, December 26th, with regards to court proceedings on what the legal people, the lawyers, will call habeas corpus. Habeas corpus. It is a legal principle that protects a person from being unlawfully detained. Habeas corpus. We are learning the law gradually. we the street lawyers. All right, to proceed, let me issue a disclaimer. This discussion is purely for legal education and public understanding. It is not intended to prejudice any ongoing case, disrespect any court, or influence judicial proceedings. The analysis is based solely on Ghana's constitutions and criminal procedure law. And of course, you may add the Chieftaincy Act. And whatever information that I'm sharing with you on this program is purely based on my findings, my research. Again, let's give the factual baseline for the prosecution of Sheriga Alhaji Seydou Abagre. These factual baselines are what I termed as the uncontested facts in relation to the trial. And what are they? Number one, Sheriga Alhaji Seydou Abagre was customarily enskinned by the Nayiri in 2023 to lead the Mamprosis in the Boku traditional area. He is not registered in the National House of Chiefs for government recognition. Number three, there is a chief called Naba Aninche Mabugrago Azoka. He is registered as chief, also known as the Boku Naba. Number four, there is admissibility of chieftaincy disputes between the Mamprosis and the Kusasis by the state. The Asantehene Osei Tutu II was appointed by the state to mediate this dispute. Asantehene has concluded his mediation and presented his report to the president, in other words, the government. Point number 7, Sheriga was removed from Boku by the military and detained in Accra. Number 8, criminal charges have been brought against him referencing the Chieftaincy Act and then criminal code. Number 9, by law, he is presumed to be innocent until proven beyond all reasonable doubt. Until proven beyond all reasonable doubt for guilt by the state. Number 10, the state has a burden of proof beyond all reasonable doubt on each of the offenses or charges brought against him. Last but not the least, the Minister for Interior claimed the removal of Sheriga was pursuant to Otumfuo mediation report and that Sheriga is safe in the care of the security agencies. That is what the Minister of Interior told us. Now, let's make it clear to the Minister of Interior and then the government that the safety of Sheriga, the health of Sheriga is in the hands of the government. The life of Sheriga is in the hands of the government. The government has given us assurance that Sheriga is in safe hands. We do not want to hear tomorrow that Sheriga is sick, that this and this and that and that. So please make sure that you always remind yourself of that responsibility, my dear brothers and sisters. Now, who is Sheriga? Who is Sheriga? Many people who are joining me today may not know who Sheriga is. But as I indicated, Sheriga is a native of Boku. He is a Mamprusi, and he was customarily enskinned as chief for the Mamprusis in the Boku traditional area. He is the supreme leader of the Mamprusi people in the Boku traditional area. A little background between the Kusasis and the Mamprusis in terms of ethnic tradition. The Mamprusis practice a chieftaincy system that is historically dynastic and rotational. It is grounded in lineage, continuity. The Mamprusis practice a chieftaincy system which is historically dynastic and rotational. It is grounded in lineage continuation traced through successive Nayiris since the 18th century. The record is there. The Kusasis, on the other hand, another ethnic group, they practice the Tindanaship system. However, the Kusasis' claim to chieftaincy reflects a more modern, modern concentration, right? It started in 1957. That is within the post-independence period. If you study the tradition of the Kusasis and the Mamprusis founded chieftaincy in the Boku traditional era, and that is their tradition, started from the era of Nagbewa. The Kusasis tradition, traditionally, they practice the Tindanaship system, not the chieftaincy system. However, as I indicated, in 1957, the Kusasis transitioned to chieftaincy. And they also adopted the rotational succession plan. Maybe one day I will tell you the Kusasi gates. They have about, I think, 6 gates. So they also adopted the Mamprusi rotational chieftaincy succession, but they don't practice it. Again, they also adopted a customary law in 1958. I've written an article on that, but they don't practice it. So these are the two distinct differences between the Kusasis and the Mamprusis in terms of ethnic tradition. Now, back to the question, who is Sheriga? Sheriga, as I indicated, was enskinned in 2023 by the current Nayiri, Tidugma Nayiri, as a chief of the Mamprusi people in the Boku traditional area. He is the 15th chief among the Mamprusi dynasty. His father was a prince, and his grandfather was the 11th chief of the Boku traditional era, the 11th Boku Naba. His great-grandfather was the 7th Boku Naba called Namamboda. Namamboda's father was the 5th Boku Naba called Namahama. Namahama's father was the 4th Boku Naba called Namahamadu. Namahamadu father was the first Boku Naba called Na Ali, who was Enskinned in 1721, and he ruled for 10 years. Right? So that is, when you come to the Mampusi, his dynastic, right? There are 4 active gates and then 1 dormant gate, which makes it 5. Now, Sheriga is from the Nakolga's Royal Gate. Now, when you come to the Kusasis, they also have in their entire history 2 chiefs. The current Kusasi Boku Naba Aninchema, and also his father, who the Kusasi Enskinned as a rival Boku Naba in 1957. So that is the history in terms of chieftaincy succession, in terms of tradition between the 2 ethnic groups, my dear brothers and sisters. Now I'm going to play some videos for you. You know, I usually like to do that so that we'll bring our discussion into, proper context for viewers to follow what is going on, what is happening. Once again, the title for tonight's program is The Trial on Sheriga Lalhaji Seydou Abagre, a customary chief enskinned by the Nayiri. Now, Sheriga is currently facing criminal prosecution. Yesterday, his lawyers were in court to argue on what lawyers called, or what the law, what is in the legal, what is it? Let me say the legal industry, right? As habeas corpus. I hope I'm pronouncing it right. Now, what is that, and why did the lawyer of Sheriga or lawyers of Sheriga file for that, and what happened in court? Now, the essence of the trial of Sheriga, this program, is, again, as I said, to educate and try to bring public understanding on what is going on. But primarily, we want Ghanaians to see whether the accused is being given fair treatment in terms of his human rights, in terms of fair trial and all that on the part of prosecutions, right? And there's a reason why I'm saying on the part of prosecution. The evidence I'm going to produce in this program will show. But before we go into that, let's listen to this very important message from one sheikh.
I think that matters of chieftaincy are rooted or are founded on the foundation of tradition and culture and history. And so sometimes, in my view, we should create opportunity for those who are very conversant with this tradition, the history, and the culture to come in as, if you like, the non-formal approach to dealing with matters which sometimes use of governmental enforcement may not be able to solve. And my hope is that where we are, government will look at the best way and put together this idea of eminent chiefs who probably their weight and eminence may give them the opportunity to be able to bring some solution to the problem. They may not be able to solve it immediately, but at least where we are, what we are interested in now is to silence the gun. I think that matters of chieftaincy are rooted or are founded on the foundation of tradition and culture and history. And so sometimes, in my view, we should create opportunity for those who are very conversant with this tradition, the history, and the culture to come in as, if you like, the non-formal approach to dealing with matters which sometimes use of governmental enforcement may not be able to solve. And my hope is that where we are, government will look at the best way and put together this idea of eminent chiefs who probably their weight and eminence may give them the opportunity to be able to bring some solution to the problem. They may not solve it immediately, but at least where we are, what we are interested in now is to silence the gun.
All right, my dear brothers and sisters, what do you think about that mistake? And this was, I believe this was either before the engagement of Otunfuo as a sole mediator. But anyway, we now know how that ended. I do not think his suggestion was taken holistically. But let's not go into all that. Let's concentrate on what happened in court yesterday. To do that also, let's go to the genesis. I'm going to play some video of the lawyer of Sheriga addressing the media. And then, of course, the first time in court, and then his address to the media the second time in court. I will also play a video, or in one of the videos, you will also hear the Deputy Attorney General, who is the lead prosecutor in this case, what he also told the media, what he told the Mamprosis. And I'm going to highlight one or two things there for you. So let's start with this video from the lawyer, one of the lawyers of Sheriga.
Yeah, he's very bitter and very sad about the situation because this is first son, Baba Saidu Abdullah, right? He's the only one who has been given access. Look, let's start this with the protocols, right? Look, I don't want to go to the merits, but I want to deal with just the, let's deal with the human being, okay? He's human. He has a family. So, and not just an ordinary family. We all know who sent him there. So if you pick such a person, what I'm saying is that our protocols would demand that, number one, at least you send a delegation, a message to the Nayiri that, oh, this man, I'm using man because I don't want to go into the merits. You put him Boko. We have taken him. He is here. As we speak today, the Nayiri, the overlord of the Mampushi kingdom, he's not being informed where this is Saidu Abariga is. He's not being informed. And that one, you don't need a lawyer. That's the thing that beats my mind. That as a nation, we govern in such a disorderly manner. And I mentioned it. I'm not happy that the Minister of Interior hasn't reached out to him. You have to reach out to him that, oh, Chief, listen, despite everything, we've taken your son. We've kept him at this and this look. Anytime you need him, you can come. That has not been done. I think that shows a lot of disrespect. It's not good. We can't do that. We can't do that.
Now, we moved, or he was supposed to leave Boko or stay there. Now, what you're telling us is that he's with the National Intelligence Bureau.
Yeah.
Is it in furtherance of that report, or there's a criminal case that he's facing?
Say that again. So I have not been told. Okay, I've been his lawyer in times past. At least this is about the third or fourth case I'm doing for him. So as part of the protocols, even I would have said, okay, you said to see which lawyer have you dealt with in the past. Can we call him in? I have not been contacted. I expect that the state is the state that took him. So look for his lawyers. Or like I said, even if that is too much, at least basic, look for the Nayiri. Look for the Nayiri and inform him that, look, your son is here if you need him. But what they did was to just look for his biological son. But Saidu Abariga doesn't belong to his biological son. Customarily, his biological, that is his son. He doesn't control him. Ask for those who have authority over him, his uncles, etc. So that's how you go to the Nayiri. So there are protocols. Or simply, if you had looked for his lawyers, and I not just look, I have said it previously, I sought to contact authority. So I contacted Mutaka, Minister for Interior. He said he didn't see it early. By the time he came back, it was about 4 or 5 days earlier. Later, after we had come on air and complained that we felt his rights were being abused. And then after, I was being told to come through protocols, right to rights, etc., before I would see him. But that doesn't even solve it. Even if I wrote a letter, it doesn't solve the detention. The key thing we need now is that he be freed, because he's not been told of any, as far as I get second-hand information from Baba, he's not been told about any crime he's committed. And even if he had committed a crime, let's be very clear. You see, the Constitution is clear that if you arrest a person on grounds that he's committed an offense, right, within 48 hours, let's be very clear, within 48 hours, take that person to court so that the person too can apply for bail. Let's be very clear. The table number 4 versus Attorney General number 4. Take the person to court. It's the judge who will then listen to the state, whether NIB, police, national security, or which other institution, and then listen to the suspect or the accused and his lawyers. Then the judge will make a determination. So let's be very clear. The fact, I'm not saying in this particular case. So in law, even if Touchwood, Hansen, I was to pull a gun and shoot you to death, it doesn't mean because everybody here is on camera, you first seen people shooting Hansen, it means that you can just throw him into custody for any long. The law is that within 48 hours, take Pebu to court, and then I'll, through my lawyers, have something to say to apply for bail. Then we'll see. Well, don't take that for granted. Let's not think that, oh, but the evidence is clear. Hey, the evidence will not always be clear. There are reasons why we didn't start today. Even previously in the 1969 Constitution, it was 24 hours. In 1969, if you read the 69 Constitution, if you arrested a person, you were to bring him to court within 24 hours. Today in Nigeria that we pride ourselves that we are better than them, they still have 24 hours. And we took ours back to 48. And now even 48 hours, we are breaching it. So let's fight for that. It doesn't matter. Even if you saw the crime with your own eyes, the law is that don't keep the person beyond 48 hours. Take the person to court. Let the judge listen to the two sides. The judge is supposed to be the impartial arbiter. Even though sometimes you may say, oh, once you see the gun, that one, over 90%, the person will not get bail within 48. Yes, but you go. The moment we want to use our own minds and say, oh, this one, the lie, he won't get bail, so we will not take it. It's wrong. Let the judge say so. Don't decide for the judge. That's what we are fighting for. If we don't protect Article 14, Clause 3, that's the way they will continue breaching it, and then it will come against us. You saw how eventually I was arrested. If years ago I hadn't come to court, several cases, you hear Martin Pebu number 1, number 2, number 3, number 4. I'm sure the day the OSP arrested me, I probably would have been kept there far longer. So you also have a duty to push to make our society better.
You also have the duty to push to make our society better. And that is what Voice of Mamprugo is all about. Now, if you listen to Martin Kwebu very carefully, he did not hide the fact that the human rights, basic human rights of his client have been trampled upon. Even he, the lawyer, as at the time he was addressing the media, never had access to his client. Let's also understand that, or let's remind ourselves to the fact that when Sheriga was removed from Boku on 24th December last year, the Ministry of Interior issued a press release signed by the Minister for Interior, telling us that the removal of Sheriga from Boku to Accra was in pursuant to the recommendations of the Asante-Henne's mediation report. And you and I know that in the Asante-Henne's mediation report, Asante-Henne said the Nayiri should recall Sheriga to Nayiri and reassign him a traditional role. Or Sheriga should stay in Boko and not hold himself as Bokunaba. That was specifically the specific recommendation that Otunfo made in relation with Sheriga as a person. Now, I don't want us to go into whether Otunfo's recommendation is has merit or not. I don't want us to go into that, but let's stay focused. So that was what the recommendation said. The recommendation never said remove Sheriga from Boku and go and prosecute him anywhere in the country. So the question is, why did the government, through the Minister of Interior, told us that the removal of Sheriga was in pursuant to the recommendation of the Asante-Henne's mediation report? When the government is acting contrary to the recommendation. So let's take that as point one. Let's take that as point one. I just want us to have a clearer picture and understanding of the nature of the trial of Sheriga. And trust me, I can tell you how the trial is going to end. That is why I'm trying to bring the education for all of us to get the picture very clear. Ghanaians. So that is point number one. Point number two, when they arrested Sheriga and took him to Accra, they only allowed one person from the family to see Sheriga. Sheriga never had access to a lawyer, which is also a constitutional right. That's point number two. Point number three, Sheriga was never told why he was arrested, which is also against the Constitution of the Republic. So point number one, the government acted contrary to the recommendation, though the government claimed that it was acting pursuant to the recommendation. Point number two, the government denied Sheriga access to a legal representative when they arrested and detained him. Point number three, the government never, or the state, though I can use them interchangeably, the state never told Sheriga why he was arrested. Now, let's go and listen to the Attorney General. Now, when that happened, let me put it, when that happened, Sheriga's lawyer knew that this was a violation of the human rights of Sheriga. So he applied to the court on what lawyers would call habeas corpus. And as I already indicated, habeas corpus is a legal principle, right, that protects a person from unlawful detention. So basically, the lawyer of Sheriga was trying to file an application and habeas corpus at the court to tell the court that my client has been arrested unlawfully. So I want you to give an order for his release. Now, let's continue the story from this video.
A greater part of yesterday's afternoon, very sharp reflection. Had conversation about his work, And so I can assure the public and people of Boku that Alhaji is in good spirits. He was with his son when I visited, and we had a conversation about a number of things which I cannot disclose. About today's proceedings, we chose to, this is a human rights issue as well, so we decided to step in instead of waiting to be formally served, which will prolong the matter to appear and then cut short all the processes. I think we made a lot of progress today in court. There's some basic understanding, yet we have some of the issues not, we do not agree on some of the issues. One of which is the lawfulness of the detention. As you may be aware, the detention is pursuant to a court order. So that we believe constitutes the ground. And if the court order is not lawful, as I see my learned friend argues, I think there is a way of dealing with that, and that we do not believe should be habeas corpus application. But then again, the judge has adjourned the case to 26. We will come and then conclude the matters. But in the meantime, I've just heard counsel's concern about access to these clients. That will be facilitated, and we have access to clients. And because the client is in touch with his family who have been there. So if counsel is raising the objection, we will definitely do that. Thank you very much.
Day 8 to 1 8, I've not seen my client. When I asked to see him, the NIV declined. I asked the Minister for Interior, they declined. They told me that I should go and write a letter, something that we don't do. So effectively, that's further delay. So I see it as a denial, etc. So we want to see him. I haven't seen him in 8 days, not in Crime Information Ghana. But that notwithstanding, I will appeal to Nayiri and the subject that they should be patient. Let's be patient. Between today and 26, there's not much time. Okay, so I'll ask for calm. That's very, very important. Let's have peace. Let's have some calm. No matter what, 26 will come. Then we will get to the bottom of this matter.
On 26, when we come, what should we be expecting?
So that day we would argue, meaning that we are saying the detention is unlawful. It looks like from what the Republic is saying today, they don't agree that the detention is unlawful. So that they will argue and then the court will decide. The business. Okay, when Chief was arrested in December 2025, right? We applied to the court that his detention was unlawful. Yes. And then we had
Give me the way.
there are several steps. When you apply that the detention is unlawful, there are a number of steps. Some of them are that then a day is given for you to appear before the judge, right? In order to explain further what you've written on paper. So that the judge agrees, then the judge will order that they should bring Chief. So that, and also the state should come and explain why they've arrested him. So to make a long story short, in this case, the judge eventually made the order that they should explain why they arrested Chief. So today, that's why we came. Now, they put their explanations. But you also know that last week, we went Tuesday or so, we came here, right, because they had filed another, or let's say they had filed a case against Chief. So now there are two cases. We filed to the court that his arrest and detention is unlawful. Then when they saw that we're winning, they brought midnight charges. Last week, I was even surprised. I was given just 43 minutes to come to this court, right? When we came, they had filed a criminal case against Chief. Of course, the charges are not strong, but that's a different matter. So today we came to see whether we can get him out based on the earlier case we filed. But as I've explained, because of the criminal case, the court had to prevail upon us that look, we should be practical. Looking at the criminal case, it's not good to continue to say we want Chief released. So eventually, we agreed. So we canceled the case where we are asking for Chief to be released. That's what we call in English the habeas corpus application. We canceled the habeas corpus application. So now we are left with the criminal case. And last week, when we applied for bail, the court didn't grant bail. But be patient. we are coming back to court on the 2nd of April. You know, such cases, I'm sure you all would see that generally it's because of the security of the situation. It's because of the state, okay, of affairs. Because there is fear. We don't believe so. Chief has always been involved. We don't believe that if the returns it will lead to any chaos. But that is what the state says. So you be patient, let a bit of time pass, and then eventually we'll get it out. Okay? Yes, so patience. The watchword is patience. He's not going to stay there forever. No. He's not going to stay there forever. And he's not in a cell like a criminal. He's not in a cell like a criminal. Okay, the treatment is different. If
All right, thank you very much, ladies and gentlemen, for staying tuned. Let me make a quick comment about the lawyer for Sheriga. I think he's doing his best, supported by other lawyers. I think they are all doing their best. He actually is the lead counsel, but he's supported by other lawyers. I don't want to mention names. But since he is the face of the legal team, let's maintain, let's do all references in his name and image. I think he's doing well. I believe he will put in his best. But I do know it's not going to be an easy task. So Mampugu, we need to rally together. We need to support the legal team. We need to support our leader, Sheriga. We need to support each other, right? We must understand that it is about Mampugu and it is about the Nayiri. Each and every one of us should want to make Nayiri proud. All right, now let me unpack what the Deputy Attorney General said. And it's very, very important. I am the type that always pay attention to details. So you realize that most of the times, even when I'm in a group, issues that I will raise, other people may think it's trivial. But if you are the type that pay attention to details, you always wanna highlight everything that matters, because sometimes the things that we think they are trivial, those are the critical things that we rather need to be paying attention to. Now, I started by saying that I'll come to the habeas corpus and then what happened in court yesterday. I just want us to have a chronological understanding of the trial of Sheriga. This is part 2. And as I'm saying that Sheriga was removed from Boku on 24th December last year and taken to Accra under detention and put on detention. The government, through the Minister of Interior, told the nation that Sheriga was removed from Boku to Accra pursuant to the mediation recommendation of Otumfuo Osei-Tutu II. But you and I know that work issue. Good, it's back. So point number 1, let's take note of that. The government removed Sheriga and from Boku to Accra and put in detention, claiming that it acted or it was acting pursuant to the recommendation of Otumfuo Osei-Tutu's mediation report. But you and I know that Otumfuo never recommended in his report that Sheriga should be criminally prosecuted. That's 1. 2, when they removed Sheriga to Accra and put him in detention, Sheriga has the right to a lawyer, but they denied Sheriga the access of a lawyer until a week or, let me say, days later. Point number 3. When they removed Sheriga to Accra and put him under detention, I would say he was arrested. Let's put it that way. Let's use the right legal term. He was arrested. And if you are arrested, you have the right to be told why you are arrested or why you are under detention. The government never told Sheriga so. That's point number 3. Point number 4. The Attorney General, the Deputy Attorney General, representing the government that is prosecuting Sheriga, went and met Sheriga. They refused Sheriga's access to a lawyer. However, they went and met Sheriga. Right? And when he came out, you can hear him in his interaction with the media. He acknowledged that one of the issues relating to Sheriga raised by his lawyers is human rights issues. So the state itself, the government itself, knows that Sheriga has fundamental human rights guaranteed by the Constitution. But the state refused to give Sheriga access to enjoy, to allow Sheriga to enjoy those constitutional rights. So tell me, you are prosecuting me, and it is a criminal prosecution. You are seeking conviction, and you know it is my right to have a lawyer to defend me from being convicted. You, the one who is prosecuting me, you refuse me access to a lawyer, but you rather came to meet me. Right? You also know and you admit that there are human rights issues. Right? Nonetheless, you refuse to allow me to enjoy those human rights issues. All right. Now, this is what he said. So, one, as I said, he indicated that there are human rights issues as well, meaning the criminal prosecution that the state is having against Sheriga. They also admitted that there are human rights issues as well. Now, he said that the state decided to step in. You see, when Sheriga finally had access to a lawyer, and we can all hear the lawyer complain or lament on how he struggled to get access to his client. Long story short, finally, he got access to the client. But even before that, he was approached and he filed an habeas corpus application on behalf of the client that he has never had one-on-one, the opportunity to talk to one-on-one, right? When that happened, the habeas corpus, as I said, and as we already heard the lawyer saying, the intention was to use that to get the court order the state to release Sheriga for unlawful detention. The state then stepped in, as we heard that Deputy Attorney General saying. The state then stepped in that instead of waiting, let me see if I can quote him. We decided to step in instead of waiting to be served, which will prolong the matter. No, he's trying to be very smart, right? He said, "Oh, yeah, we admit that there are human rights issues, right? Now, Sheriga should have access to lawyer, but we disagree that he was unlawfully detained, and now that his lawyer is applying to the court to get him released, we have now decided to step in. And we are stepping in because we don't want the process to be prolonged. We want to step in and cut the process short. Listen, cutting the process short is releasing Sheriga. If you are granting him bail, grant him bail. There's nothing that you are going to do that is not prolonging the matter, right? And I'll prove to all of you and to the Deputy Attorney General that he was deceiving Ghanaians, the people of Boku, and the Mamprosis in particular, when he said that they stepped in so that the process will not be prolonged. I'll explain to you why. Now, he went on to say that there are basic understanding between the two, the prosecution and the defense team. There were some basic understandings in court about some of the issues. However, there were a couple of issues, right, that both of them did not agree, which is the lawyer of Sheriga is saying that you are detaining my client unlawfully. The Attorney General, which is the government, on behalf of the government, is saying that no, we don't think that we are detaining him unlawfully, right? But he then went on to say in the video that can be corrected if you listen to him carefully. It was after that, and this is how he corrected it, after that the state then quickly filed criminal charges against Sheriga to try to correct the wrong that they did. So you see how, let me use the word, I don't want to say tactical, right? But let me say deceptively tactical, right? It's like, oh, we are trying to do this and that, but behind the scenes, they are rather trying to put fuel, to put petrol in fire. That is what the NDC government is doing to Sheriga right now, my dear brothers and sisters. So then let's go to point number 6. When the lawyer of Sheriga applied to the court for the habeas corpus, the case was, what is it? It was set to occur on 26th, which was yesterday. And indeed, the case came on yesterday. Now, this is where we are now transitioning to what happened in court. Now, this is another point that you need to take note of. Point number 7, as the lawyer indicated, he described it as midnight charges, right? So, the Deputy Attorney General, listen, I just don't know how to present this so that you all get the clarity. But let me repeat myself. The Deputy Attorney General, remember, said that they decided because they acknowledge that there's human rights issue. And based on the human rights issue, the lawyer for Sheriga applied for habeas corpus. And they don't want the issue to prolong. So they here means the government, because the Attorney General is acting on behalf of the government. So the government stepped in. And why did the government step in? The government stepped in, according to the Attorney General, not to prolong the process. Now, if you say you don't want to prolong the process, it means that you don't want the continuous detention of Sheriga to be prolonged. That is the reasonable understanding that any reasonable person will have. Right? Good. Now, you then, after that, you then left and then later on brought in midnight charges, criminal charges against Nayiri, which is to try to correct the unlawful detention. And as I told you in the first program, now that charges have been formally brought against Nayiri, it means that the Nayiri is no more on unlawful detention. You cannot argue that he's being unlawfully detained, because the matter is now with the court. So it is now for the court to decide to grant bail or not to grant bail. We'll go into details with that. But I'm trying to explain to you why I described the conduct of the Deputy Attorney General as deceptive tactics. Now that you file criminal charges against Nayiri, you are the same person that you want to you don't want the process to be prolonged. The problem is that we want Nayiri to be released. You are saying you want to cut the process short, so you are stepping in. And the best way you are stepping in is to file criminal charges, knowing very well that filing criminal charges against Nayiri means that it is now left onto the judge to decide whether the judge will grant Nayiri bail or not. So you see how the DC government is playing with this issue. Now, okay, so let's continue. So yesterday, and then take note this point number 8. When the lawyer of Nayiri applied to the court for the habeas corpus, the court directed the government to file a response, that is, to come and tell the court why the government is detaining Nayiri, why the government removed Nayiri from Buku, brought him to Accra, and put him in detention. So that was what the court asked the government to do. And then the government was supposed to file its reasons for removing Nayiri and detaining Nayiri on 21st of this month. Now, guess what happened? The government never filed its report on the 21st that the court requested or directed that it should. The government rather did that yesterday in the morning, virtually putting the lawyers of Nayiri off guard. The lawyers of Nayiri went to court, and it was there that they were handed the government handed over its response to them. The government was supposed to do that on 21st so that the lawyers of Nayiri can study their response from 21st, 22nd, 23rd, 24th, 25th, so that at least they can have 5 days to study the response of the government, to enable them also make their response if necessary yesterday. But the government never filed its response until yesterday. This is the Deputy Attorney General who told us that he doesn't want to prolong the thing. So that's why they stepped in. And I'm told that in court, back and forth, the lawyer for Nayiri said, listen, I need time to study this to respond. Right? And the judge was encouraging him to make his oral submission or response. And from my reporter, the Deputy Attorney General, that is the government, said that if the lawyer for Nayiri filed a response to his response, he will also file a response. In other words, he was telling you that, listen, we will do back and forth on legal gymnastic and all technicalities and all that. And your client virtually will continue to be in detention. So the lawyers for Sheriga then decided that, okay, you know what, let's be smart here. So instead of insisting on making a written response, they will make preliminary response orally in open court. And one of the issues that was raised by the government, or the reason why they arrested and detained Sheriga, is they mentioned PNDC Law 75, they mentioned the Supreme Court ruling, and then they also allege that about 130 something people died, and they are blaming it on Sheriga. The lawyers of Sheriga also stood and rebutted all these three reasons. So that was what happened yesterday. Now, the case has been adjourned to February 2nd. I can tell you that the case against Sheriga, as far as the state is concerned, they are going to use what they just stated, the Supreme Court ruling, PNGC Law 75, and whatever, as their evidence to support whatever charges that they have brought against Sheriga in his prosecution. I pray that Sheriga will get fair trial. I pray that the government will not continue to detain Sheriga beyond the number of weeks that it has already put Sheriga in detention. I pray that Sheriga would be granted bail on February 2nd so that he can have more time with his lawyers, his family, and his father, the Nayiri. Now, when that happened in court, the lawyers of Sheriga also did something that was very smart. They then said that, okay, since there was now substantive charges brought against Sheriga, it means that technically there is no need to argue on the habeas corpus, because Sheriga was now under lawful custody through the courts. So what it means is that now on February 2nd, the major objective of lawyers of Sheriga will be to apply for bail for Sheriga. Now mark this. Remember, the Attorney General told us that the government want to cut the process short. That's why they stepped in, right? And step in here, he eventually brought criminal charges against Sheriga. He surprised the lawyers of Sheriga, right? Now, let's see whether on February 2nd, the government will kick against the request of the lawyers of Sheriga for a bail to be granted to Sheriga. Let's watch and see how that will play out on February 2nd next month, my dear brothers and sisters. So basically that was what happened. And when I said the lawyers of Sheriga took a strategic and tactical decision to withdraw their argument or their case, or their habeas corpus case, it is a smart decision that they took. And the reason why it is a smart decision is that it still gives them the opportunity to reapply for habeas corpus just in case it becomes so necessary. Again, just in case. So I think that was very smart. And you can relate it to the way the lawyers withdrew the application, in 2003, when they withdraw the application to continue with the constitutionality or otherwise of PNDC law 75. So basically, that is what happened in court, and that is how the trial of Sheriga is going. That is the trajectory it is taking. I want us to follow it closely. Voice of Mampugu will try our best to always throw more light into things that are not very clear in terms of the legal issues and all that, so that we can all be educated. Again, as I said, our main agenda is not just for legal education and public understanding, but also to play a civic role by holding the state, the government accountable to respect the human rights of Sheriga and to handle this process fairly. Handle this process fairly. My dear brothers and sisters. So this brings us to the end of tonight's program. I will see if I can take some of your comments. I may acknowledge one or two of your comments. Now, let me reissue a disclaimer. This discussion is purely for legal education and public understanding. It is not intended to prejudice any ongoing case, disrespect any court, or influence judicial proceedings. The analysis is based solely or purely on Ghana's constitutions, criminal procedure law, and the Chieftaincy Act. We are just educating the public what happened in court and also some of the things that happened prior to the criminal charges brought against Sheriga Alhaji Seydou Abagre, a customary chief Enskinned by the Nayiri 2 years ago. Ladies and gentlemen, thank you so very much. Let me acknowledge my dear Auntie Deborah Adam. Said, call me if you are done. I need your help. All right, I promise, Auntie, I'll call you as soon as I'm done. We have, is it Pualonaba? Pualonaba, forgive me if I'm not getting your name right. Said, history is like death. Whether you believe in death or not, it will surely come because it is continuously one way. It's continuously and was being programmed by Allah himself. Thank you very much. Let me take. I said, Dahmani Isifu, God is not somebody's father. So now all the Mampusis, we will start cursing Kosasi's aunt. Take it easy, my brother. It shall be well. It shall be well. For me, the most important thing is that let's not lose faith in God. Let's not. Let's continue to put our trust in God. But of course, we also have a work to do, and that is always my concern. You know, as I keep on saying, there are certain things that I just need to say, but I'm also very mindful of not saying everything in public. But sometimes the little hints that I give, I believe that those of you who read my comments or who sometimes listen to me on this program, you get the picture I'm trying to paint, right? Mamprugo, we are sleeping. Trust me, we are millions miles far behind, and we are still refusing to wake up. That is my worry. If not, there is no problem that is greater than our ability to handle it. And I'm going to conclude by also saying that let's appreciate our leaders. They are doing a lot of work behind the scenes, even though we may not be satisfied with everything that they do. We may not be satisfied with their actions, some of their actions and inactions. That is understandable, you see. And then, anyway, I don't know. I am always on your side, the grassroots. I mean, the leaders, they will tell you how, if I get the opportunity to be with them, right, they tell you how I disturb them, right? So the point I'm trying to make is that, yes, let's hold our leaders accountable, but let's also sometimes pause to appreciate them. It is a voluntary, sacrificial work that they are doing, all of us. But I'm saying that leadership is very important. Let's not demoralize them. Let's not make their work difficult for them. We may disagree. We may not like the way they are doing their things, but they are our leaders. They are our leaders. And I always say that I like the situation where not even just leadership, even whether siblings or friends or whatever. For me, I don't mind fighting you. When I say I don't mind fighting you, what I mean is that when you do something that I think I must tell you that it's not right, I will tell you. Even if you will not be happy, if you fight with me, let's do that, right? But at the end of the day also, let's reconcile. Right? So I'm the type that I like, yes, let's fight. But after fighting, let's know that we put the fighting aside and move on. Right? So let's criticize our leaders when the need arises, but let's not also mishandle them. I think that is how I should put it. Let's not mishandle them. They are doing a lot, right? They are doing a lot. I'm the type that I always want to be the watchman, right? The one who is behind the scenes, trying to put them on their track. I prefer to play that role. And then many people don't like me because of that. But anyway, all right, ladies and gentlemen, I'm just having fun on tonight's program. So thank you so very much. This has been the trial of Sheriga Alhaji Siru Abagri, a customary chief Enskinned by the Nayiri. Thank you, and may God bless you. Peace and one love.